Hello everyone, welcome and thank you for joining our webinar today. My name is Lucy and I'm the Marketing Executive here at Vaultinum. For those of you who aren't all too familiar with Vaultinum, we are a European trusted third party established in 1976, and we specialise in the protection and audit of digital assets. And today we're going to be discussing the best practices to protect your software and prevent intellectual property theft. Regardless of the sector of activity, intellectual property increasingly defines an organisation and determines its future. It is more important than ever that businesses understand the value of IP and the extent of their IP rights, whilst also taking action to implement sufficient strategies to protect them, which is becoming increasingly difficult to do so in today's interconnected world. The purpose of our webinar today is to give an overview of the IP protection rights granted to software and explain how you can take the steps to protect your software creations regardless of which stage of the business lifecycle you're currently at. We will then address any questions that may arise during the final 15 minutes of the session, which you can type into the chat window throughout the webinar. I would now like to welcome our speaker for this afternoon, Kristen Avon. Kristen is our Senior Legal Officer here at Vaultinum. She has previous experience working in multiple high-tech industries, as well as international experience across areas of IP law. Hi, Kristen. Thank you for joining us today. Why don't we start just by discussing the basics? In the context of a company, what exactly is intellectual property?
Hi, Lucy, and thank you. I always love doing these webinars with you. And hello to everyone. Thank you for joining us today. So yes, in the context of a company, or really any context, intellectual property is a legal regime that protects from unauthorized use certain creations of the mind. So in a business setting, this we usually refer to it as the intangible assets. But what do I mean by intangible assets? So intangible assets in a company look like the brand name, client list, patented technology, website content, and software. These can be contrasted with more physical assets of a company. So we're talking the land, the buildings, the computers, machinery. These are assets which can be protected physically. We can construct a fence, install a security system, hire armed guards. Whereas with intellectual property, the risk is that it could be replicated and distributed after the very first sale or publication. And this is the reason why they are provided special protection under the law. So for the purposes of our discussion today, and just to keep things simple, I've organized various IP rights. One, those requiring registration, those not having any formalities, and those lacking a more uniform treatment across nations. So in the first column here in the pink, we have IP rights, which are subject to mandatory registration. This means that upon creation, the author, inventor, creator, they must register their creation with a specially dedicated organization. These are primarily patent, trademarks, and industrial designs. This mandatory registration ensures that they are visible to third parties and protects them from potential counterfeiters. In other words, for these types of IP rights, no registration, no ownership, so no real protection. Next, we have the inverse situation. These IP rights are not subject to mandatory registration. Primarily, these are copyright and trade secrets. So copyright covers works of a literary and artistic nature. So think films, music, books, software, paintings, sculptures, and the like. Trade secrets covers data or more relevant information, which has is commercially relevant and is kept under lock and key. So here we're talking Google's search algorithm or the recipe for Coca-Cola. So in this column here, no registration, but you have automatic coverage, but protection in general is made less easy. And lastly, we have other non-traditional IP types, including domain names, consumer databases, and publicity rights, among many others. These all have general, but not necessarily universal recognition under the laws of many nations. And altogether, these make up intellectual property, and they are protected by one or more legal regimes.
Thank you, Kristen. I know that's quite a general introduction to IP, and I know that can be a complex area, so thank you for giving us that summary overview. But what are the advantages of identifying and then ultimately protecting these assets?
So this gets to the heart of modern intellectual property law. And that is to provide an economic incentive for both people and businesses to create goods for society by allowing the creators to profit from their creations. So for companies, means they're going to be incentivized to bring us new cutting edge technologies like electric vehicles, virtual realities, clean energy technology. Artists and authors, they can create without the fear of their work being stolen or copied at the first public display. So the result is mutually beneficial. Society is enriched by the disclosure of new knowledge, and these IP owners can be rewarded financially for their efforts. So for companies, being able to identify, protect, and enforce their IP rights, there are three main benefits. So first, and quite obviously, it's an important source of revenue. The proper management of IP throughout the entire product development cycle is critical. It's a critical factor in the successful commercialization of the end product or services. Sorry, it's sorry, just lost myself in these notes. So what it also does is it provides a monopoly to the IP owner, and it builds barriers to entry for competition. It also, companies that secure their IP increases their credibility and even value in the eyes of partners, investors, lenders. Being able to prove IP ownership can be critical to obtaining funding, for example, during the commercialization process.
Thanks, Kristen. So it almost goes without saying that the heart of many businesses is their IP. And of course, this is especially true for organizations that make or license software. So can I ask you to talk a little bit about the software assets and where exactly that fits in within the IP landscape?
So yes, so software, if it meets certain conditions, is awarded protection under copyright. So let's talk about copyright. Copyright protects the original expression of an idea in the form of a creative work and not the idea itself. And I'll give you an example of this in just a moment. But copyright protects all expressions, whether they be literary, artistic, educational, or musical in nature, and computer software falls under its purview. So we know already that copyright does not require mandatory registration. In fact, it is automatic at conception, but it must meet certain conditions. And this is that it be materialized and original. So on the first, what does it mean to be materialized? So on the left here, in my pretty little design, we have a circle within a circle. So a circle, it can be drawn, built, photographed, but there's nothing original about it. Yes, we can make it tangible, but it's not original, so no protection. Similarly, we have plagiarism. So someone pirates a film, makes a copy, tries to sell it. Now this is certainly materialized. A film is a fixed, tangible medium, but also not original and not protected by copyright. But in this situation, we're probably violating someone else's copyright. On the right, we have an original idea or concept. So you may have an idea for an epic tale of a group of reluctant heroes who set forth to save the world from evil. But until that idea is formalized, and again, a tangible fixed medium, no protection. So for J.R.R. Tolkien to have copyright over his epic idea for the Lord of the Rings trilogy, it needed to exist outside his mind. Now, mind you, I'm not talking about the book or the paper, the ink, or the binding that is being protected, but the words and how they piece together to form a story that reflects the free and creative choices of the author. So originality and materialization, automatic copyright protection. Now, let's talk about how this applies to software. So, in the history of intellectual property rights, software is relatively new to the scene. At first, policymakers and government bodies weren't sure where exactly it fit, but they all agreed that it should be protected. Ultimately, given the creative nature of software's development, how each line of code is written and represents, again, the free and creative choices of the author, software was determined to be more artistic in nature and thus fall under the protection of copyright. But not all the elements of software are protected by copyright. Those which are those where we find creative choices. So the source code, object code, the preparatory design materials. So this could mean the mock-ups, the flowcharts, internal, external specifications, and so forth. The elements of software which are not given copyright protection are those considered the logical elements at the base of the software. So algorithms and programming languages. So algorithms, these are considered to be the logical mathematical sequence that cannot benefit from the free and creative choices of an author. And programming languages are considered the means of expression and not the expression itself. In some cases, the functionality of software can be protected by a patent. So where the program is part of a system and produces physical effects, but this is less often and a topic for another day.
Thanks, Kristen. So if I am a software developer, the moment I publish the software, I have copyright protection rights. What does this mean, and what rights do I actually have within the software?
So, Lucy, copyright confers two sets of what we call exclusive rights on the software author. These are moral rights and economic rights. So, moral rights, these are intended to preserve the author's link with the work, and only the author can exercise them. So this is the right to put his or her name on the creation itself, or the right to object to a particular use that would distort their work. So moral rights are in many jurisdictions perpetual, meaning they remain after the death of the author. While in others, many others, they generally last for the lifetime of the author plus 70 years. And these rights generally cannot be transferred. On the other hand, we have economic rights. So these allow the authors, creators, inventors to receive financial reward from the use of their works by others. So the holder of these rights can decide on the reproduction and the public representation of the work and receive payment for it. These rights may be transferred, such as when you sell or license your creation, but are time limited. Now, I have to say, national laws may contain limitations and exceptions to these rights as I've outlined them here. So it's really important to check with an expert in your jurisdiction.
So Kristen, now that you've actually mentioned that, I'm wondering, how much do the copyright laws vary from one country to another? That's to say, if I were to develop my software in the UK, but then set up my business in Spain, would I have to keep track of every country's legal requirements?
So it's a great point, Lucy. Today, copyright is largely governed by the Berne Convention of 1886. The aim of this agreement is to protect and to harmonize international copyright rules. And it's actually today recognized by 181 countries. So there are three key principles of the Berne Convention. One we are already well familiar with, and that is that copyright protection exists from the moment it's from the moment of creation without formality. And the other two key principles are related. So first we have the principle of national treatment. And this is countries who belong to the Berne Agreement, they agree to protect foreign and domestic works equally. So no matter if the author is of a different nationality or the creation was first published in a different country, works are treated the same regardless of the origin. And the second is a counterpart to this one, and that is the principle of independence of protection. So this means that protection is not linked to the nationality of the work, but the work is always protected by the law of the state where it is used and not the country of its origin. So the same work could be protected differently according to the territory on which it is used. Now, you could imagine that before Berne, there was a very fragmentary approach to copyright, right? A work published in the UK by a British national could be covered by copyright there, but then be copied and sold by anyone in France. And it would be chaos and not at all a good environment for innovation.
So, Kristen, let's circle back to my example of if I'm a software developer. I've developed a software that meets the conditions for copyright, and I know that copyright is automatic, and I'm not required to register my software. So can you tell me, if the need arises, how exactly can I prove that the software is in fact mine?
Precisely, Lucy. So in the absence of formalities, protection is made less easy. That's really what we're getting at here. And the modern digital landscape, as you said in your introduction, makes IP theft much easier and the consequences that much greater. The average IP trial, the average IP trial can last up to 3 years, and the cost of litigation, IP litigation, continues to rise, with these claims getting bigger and more complex. So without an effective IP management strategy that ensures the software copyright can be enforced, several risks arise. A company can effectively lose ownership of their code. So if a disgruntled employee or corporate spy obtains access to the source code, they can essentially have free range to use the code for their competitive or monetary advantage. You can go to trial, but it's going to cost you and your reputation. And second, when it comes to software copyright, there's also the concern about piracy, which is just as great of a concern as plagiarism, the copying and illegal distribution of the source code. So piracy ranges from customers continuing to use licensed software even though their subscription has expired, to hackers selling counterfeit versions of it. This is going to lead to lost revenue for the company overall. So there are a number of actions an organization can take to mitigate these risks, but the legal mechanism underlying them is being able to prove copyright in the software. So what does it mean to prove copyright? In order for you, Lucy, as a software developer, to be able to enforce your rights, you must be able to prove two things: that you own the rights to the work and that these rights existed at a given moment. In other words, you must prove ownership and interiority. How is this accomplished? The most trusted way is by voluntarily registering. So practically, this means making an IP deposit of the source code with an independent third party, which is timestamped and certified. And then this becomes evidence that is recognized in court. So Vaultinum provides an IP deposit solution, which allows software authors to prove their rights in court via a certificate attesting to the date the work was registered and ownership. Let's look at what it means to voluntarily register in practice with a recent case that happened here, that happened in France. Okay, so this is a case. So in this case, the Generix company developed a software for managing warehouses in the mass distribution sector. The Generix head of solutions left the company to create a direct competitor of his former employer, Generix. Generix sort of suspected something was up and was later informed by a former client that this former head of solutions was in possession of the Generix source code. Internal analyses and 2 private technical reports commissioned by a court confirmed the identity between the source codes of the software, and Generac sued their competitor for copyright infringement and unfair competition. Before ruling on the infringement, the court first identified the work in question and the owner of the rights in the source code on the basis of deposit certificates from an independent copyright registration service, Vaultinum's sister company in France. On this basis, the court ordered ASAP and its founder to pay more than 3 million euros for copyright infringement of the software source code, in addition to other damages. So, making a deposit of the source code with a trusted third party helps prove your IP rights. It is a form of evidence valid in court, and as we saw in this case, helps a company claim higher damages as the deposited source code can be compared to the infringing one.
Thanks, Kristen. That's a really interesting example of how IP deposits can protect and enforce your software copyrights. But you also mentioned that having an IP management strategy that relies on IP deposits can add value to a business. Could you elaborate a bit more on that for us, please?
Yes. So the digital IP deposit is a dual purpose: protection and valuation. So protection is the more obvious, as we saw with the Generac's case, but it can also help avoid costly litigation through out of court settlements and protect against third-party claims in general. But the IP deposit is not only a measure against legal challenges, it also allows internal and external stakeholders to better value the company. You see, if you can't prove ownership, you could scare away potential investors. It has been known to happen that several competing businesses are simultaneously working to find a solution to the same problem. In the event similar solutions are created, only the company that can prove their ownership can attract and secure investments. So having innovative software, that's the cake. It's the first element of credibility. But being able to demonstrate that your company has taken care to protect the software IP, that's like the icing. It reinforces the image of seriousness of the company and reassures investors.
Okay, so if we were to go back to our example where I'm a software developer, I've checked all the boxes, deposited the source code with Vaultinum, and ensured that any new releases are updated automatically and therefore protected. Are there any other steps that I should take to make sure that I'm on solid ground to start commercializing my software?
Well, you're already ahead of the pack. You have hard evidence that can be used in court. So you are going to protect and prevent any potential IP theft. Yes, but before you start commercializing your software, you must ask yourself whether you have full rights to license and monetize it. In other words, by licensing or distributing your software, are you at risk of copyright infringement? What I am getting at with this question is whether your company is aware of the risks inherent in the use of open source software. You are probably well aware of what open source software is, maybe not, but if not, very briefly. So open source software is made up of software libraries, modules, other components that are either purchased from third-party vendors or made freely available. It's estimated that somewhere around 75 to 90% of today's software is composed of this third-party code. And this has strong implications on the intellectual property of a company's software. Why? Because open source does not mean that the source code is in the public domain. It is not a no strings attached type of relationship. Open source means that it is freely accessible and usable under certain conditions. Conditions that are in the terms of the license, which is attached to the open source software.
Kristen, just before you go on, you've mentioned IP theft, copyright infringement, software licenses. Can you just shed a bit more clarity on how they all fit together?
Of course, Lucy. So let me back up a bit. So copyright infringement, and this is just a fancy way of saying IP theft. It's the illegal copying, distribution, or use of copyrighted material. But with software, software is unique, all right, because it can't work without being copied, right? So for a software program to run, it must be copied from a tertiary memory device to a system's primary memory. And this in and of itself is an unavoidable act of copying. However, such copying is not considered a crime because it's essential for the software to function. So the problem arises is when the software code is copied by someone with the intent to gain from such copying. This could not just be direct copying, but even an adaptation of the software could be an infringement. So to manage this copying of the software, the authors use legal instruments. These are known as software licenses, and these grant end users with various permissions and restrictions. So software licenses can be thought of as a tool against copyright infringement. So companies, they need to make sure that they are not infringing on the copyright of the software that they use or integrate into their software product. They must make sure that they are being compliant with the underlying license of the software code. And this is where the issue of open source arises.
I'm right there with you, Kristen.
Still with me? Okay, all right. Okay, so most software developers, they're not reinventing the wheel. Okay, they develop their own code with a focus on product customization, but often by writing it on top of open source and third-party components. This is a practice that is part of nearly every development team's standard. And it also makes up the majority of companies' solutions to their customers. And this is practiced throughout all industries. But it's not always understood at the executive and strategic levels. In fact, the majority of companies are not able to completely identify all third-party code it integrates into its software solution or the risks. You see, the open source licenses that I was just talking about, they are not all created equal. Some, which are known as permissive, they just want you to give credit to the author. No problem. Done. Easy. But others are a bit more restrictive, and these fall into a category known as copyleft. And they say, you're free to use me, integrate me, but if you want to sell or distribute your software that I'm used in, you need to release the full source code. So kind of a big problem if you are in the business of distributing your software. I am very, very much simplifying things, but the main takeaway is that some open source licenses impose conditions on the software's use and availability to downstream parties. And ultimately, this may decrease its value or capacity of the company to continue its operations or maintain its business. So on this slide, I've actually noted just some examples of companies that got into some hot water with open source issues. So you see here that even big names like Panasonic, BMW, Tesla ran afoul of OSS licenses. And some even had to honor the license terms, even if that meant releasing the source code.
So Kristen, how would you propose managing these risks, especially if you don't have the similar resources to some of those big name companies on the slide?
Yes, of course. So the first step for any company is just to acknowledge that the greater part of your software product does not actually belong to the company. Rather, you have to think in terms that certain parts of the software code are being licensed to the company, and therefore there are compliance issues. Non-compliance means potential legal action and reputational damage. So with this knowledge, let me change slides here. Oh, sorry. I just went backwards. Let me see. There we go. Okay. So where was I? Okay. Yeah, so you acknowledge that you don't own all of your software products. So with this knowledge, a company should develop a clear and dedicated open source policy. So this should explain to its IT staff members how to use and track open source. So you need to create an OSS inventory, have it centrally monitored and maintained. This should include identifying open source libraries that are used, as well as their licensing models. And permissible uses per licensing model, per project should be identified and listed. And this compliance should be continually monitored. To assess this process and ensure that you are implementing best practices, not only when it comes to open source, but also managing all your IP rights, we recommend running a full IP audit. So you could say there's 3 pillars of an IP audit. There's the code scan. So this, you would analyze your source code with an automated tool, and that will identify your overall OSS usage, any licensing risks, as well as many other things like vulnerabilities, cybersecurity issues, but we're just focused on the IP here. This should be coupled with an online assessment. So this is an expert developed questionnaire that will assess your IP management. So it looks at the part of your company that can't be scanned. Are IP best practices in place? Are you handling IP risks effectively? And lastly, you should have an expert review. So this expert should understand your company's priorities, put it into context of your industry and size, and give you an overall 360-degree view of your IP risks and recommendations to improve your IP strategy as it matters to you. So from securing copyright through a digital IP deposit to maintaining an OSS compliance program, a successful IP management is key to supporting your company's capability to innovate and to develop your strategic market value. So we've covered a lot today, but from the fundamentals of IP, how to protect your software copyright and proactively prevent IP theft, as well as ensure that you can make use of your innovative software the way you intended. So the main takeaways here I've listed, they also double as best practices. So very briefly, first, you want to be able to prove your rights and defend yourself in court by depositing your source code. Just because there are no legal formalities doesn't mean you should do nothing. Generax would have not been so successful had they not deposited their source code, enabling them to prove ownership and interiority, and most importantly, continue their business. Second, update the source code regularly by depositing every new version. You want to keep your rights up to date. Third, develop an OSS inventory and ensure that you keep track of the licenses and remain in compliance with them. Fourth, to help with the third, run an IP audit to assess the effectiveness of your overall IP management and strategy and get expert advice on how to improve. And fifth, run a source code scan as part of this audit to identify any OSS licenses issues and their risks. So this brings me to the end of my presentation. I want to thank you all for your attention. We covered a lot of complex issues in actually a very general manner. So if you are reviewing these slides later or rewatching this presentation and a question pops up, don't hesitate to reach out. Before I hand it over to Lucy to take questions, I just want to invite you to visit Vaultinum's website. It's noted in the bottom right-hand corner if you would like to learn more about our IP deposit and audit solutions. And of course, you can always contact us directly. Over to you, Lucy.
Thank you so much, Kristen. It's been great having you speak with us this afternoon. I see here we have a question which says, in my company, we currently store our code in GitHub. What's the added value of making a deposit with Vaultinum compared to what GitHub provides? Example, in the court situation that you've just described.
Okay. Yes. So first, for those of you who don't know GitHub, this is a web service for hosting and managing software development. So their business, they're not in the business of intellectual property. They do not position themselves as such. So for example, they don't have a legal department that is on call to discuss your IP strategy with them, for example. So yes, but it's true that GitHub does timestamp every change of your source code, just like Vaultinum, but their timestamps are not EIDS certified, whereas our deposits here at Vaultinum are. So there is a level of protection and assurance there that is absent. And also, Vaultinum has a very strong jurisprudence history. Our certificates are recognized before the court, like in the Generex case. So GitHub it's great, but if you want more protection that you can use in court, then I recommend a separate IP deposit.
That's great, Kristen.
If that
Thank you
answers
so
your
much. We've just had another question come through here. It says, hi, I am a developer based in Italy. What is the process for the IP audit, and how can I deposit my codes if I am in Italy?
So everything is done online through our website. So it's just you would just upload your source code. Your source code to a demilitarized zone. Sorry, it's immediately encrypted and stored on our servers based in Europe. So it's quite straightforward. We can walk you through it. But if you visit our website, you will see how it's done. If you need any other questions.
That's great, Kristen. Thank you so much. Actually, on the screen at the moment, you'll see there is a link to both Vaultinum's IP deposit and the IP audit solution. So you can definitely get more information there. And then there's links to chat with our team directly if you have more questions. I would like to finish this session by thanking you all for joining Vaultinum today to discuss the best practices to protect your software and, of course, prevent IP theft. We really appreciate you signing on, and we hope that you've learned more about how Vaultinum can assist you with your IP protection strategy. Feel free to reach out to us, and if you'd like to know more, please follow us on LinkedIn and keep up to date with our upcoming webinars, and we hope to see you next time. Thanks,
Thank you
everyone.
all.